Hello everyone, this is Nishtha Srivastava, legal intern under LEXIS and Company, and today I'm here to discuss the recent order that has been given by the Chhattisgarh High Court regarding no requirement of a strict proof of marriage for a case under section 125 of the CPC, which deals with maintenance provisions. The Chhattisgarh High Court, comprising of the bench of Justice Rajendra Chandra Singh Samant, observed that strict proof of marriage is not a requirement in the case under Section 125 of the CRPC. However, it's important first to discuss what are the facts of the case. So this was a criminal revision petition which was filed against the order passed in the MJC granting monthly maintenance of Rs 3,000 to a respondent under Section 129 of the CRPC. The contention of the parties. It was submitted by the counsel for applicant that the impugned order is erroneous and illegal. The respondent has failed to prove that she was legally wedded wife of the applicant, and the learned family court had erroneously held that although the respondent is not a legally wedded wife of the applicant, even then she was entitled for maintenance. It was a clear admission of the respondent in her cross-examination that she was married to one Bisahu Ram Sahu and she has a son and a daughter from the same marriage. Moreover, she also admitted that she has not obtained any divorce from Bisahu Ram Sahu from any court of law. Another circumstance that was present was that the applicant was already married to one Devki Bai, regarding which the respondent had made admissions in her cross-examinations. Therefore, the applicant and the respondent both were married and their spouses were living, hence the relation between them could not be termed as a valid marriage. The counsel of the applicant further referred to the case of Badshah vs. Urmila Badshah Godse and another, wherein it was submitted that it's not a case in which the respondent was ignorant about the previous marriage of the applicant. Therefore, she cannot be deemed to be a legally wedded wife of the applicant. The learned counsel for the respondent opposed the submissions so made and submitted that the respondent has proved her case to show her entitlement for maintenance under Section 125 of the CRPC. After the dispute arose between the applicant and the respondent, a compromise had taken place between both of them. Further, the counsel for respondent referred to a judgment in the case of Srimati Motimbai Borkar vs. Arjun Singh Borkar, wherein the court had held that respondent had married the lady lived around together as husband and wife and cohabited with her, now cannot be permitted to turn around and say that the petitioner is not his legally wedded wife. Now, what did the court actually observe? The Chhattisgarh High Court noted that the learned family court has drawn a conclusion that respondent is the wife of the applicant on the basis of the ratio laid down by the Madhya Pradesh High Court in the case of Sumitra Bai vs. Bhikam, reported in the year 1985, and on the judgment of Supreme Court in the case of Dwarka Prasad Satpathy vs. Bidyut Pravadikshit and another, reported in 1999. In which it was held that strict proof of marriage is not a requirement in the case under Section 125 of the CRPC. The fact established that the parties were living as husband and wife is sufficient to draw a presumption about their marriage. On the basis of the submissions made and the evidence present, it is found that now it is undisputed that the applicant and the respondent had resided together as husband and wife for some time. The only ground of contest of the applicant is that his marriage with the respondent was not lawful. After making such observations, the court also appreciated the evidence and on the basis of the legal precedents cited, the facts in this case revealed and said that the facts in the case revealed that the applicant had knowledge that the respondent was already married to one Bisahu Ram Sahu, regarding which the respondent claims that she has obtained divorce in a customary manner. This also is a fact that the applicant was married to one Devki Bai in the year 1992 and 1993, but there is no evidence present to show that the previous marriage of the applicant was continuing and subsisting when the marriage of the applicant with the respondent had in the year 2009. The witnesses of the respondent have also stated about the performance of the marriage of the respondent with the applicant, and also about the social meeting which was held on account of the dispute between the applicant and the respondent, in which the applicant had admitted that the respondent is his wife and had taken the responsibility for the respondent in the compromise. The applicant side has also not brought any evidence or examined the previous wife of the applicant to show that the marriage of the applicant with his previous wife was continuing. Therefore, the court noted, after taking into consideration all the facts and circumstances, evidences, and position of the law, the finding of the learned family court that the respondent has the entitlement in a grant of maintenance cannot be said to be erroneous in any respect. The court also dismissed the petition and by holding that after taking into consideration all the facts and circumstances as well as the evidence and the findings of the learned family court that the respondent has entitlement in the grant of maintenance, this cannot be said to be erroneous in any respect. Therefore, this revision petition that was filed before the High Court was devoid of any substance and the impugned order does not call for any interference. So, the Chhattisgarh High Court finally dismissed this petition, giving out the entire obiter dicta that without even if a strict proof, you can claim that you are married and you can claim maintenance under section 125 crpc if your facts and circumstances prove that you lived and inhabited as husband and wife. That's all for this video. Thank you.